Hello, my name is John Dorman. I served as city attorney for the city of Stillwater for 18 years, concluding that segment of my municipal career in June of 2021. I'm a fellow with the International Municipal Lawyers Association, IMLA, and I'm also a member of the Oklahoma Association of Municipal Attorneys, the OAMA for short. One of the missions of the OAMA is to provide those practicing municipal law across the state of Oklahoma with resources to assist in providing sound advice to the cities and towns they represent. OAMA has established a program that provides such information accessible through the OAMA website, www.okmunicipal.attorneys.org. My topic is preemption, what it is, how the courts recognize it, and how it impacts municipal policy and operations. Why discuss preemption? There's a national trend of state legislatures to restrict the ability of municipalities to regulate in areas that have traditionally been the exclusive province of local government. This is particularly true the past 10 years. It's not limited to any particular subject or any particular geographical area. Who and what are driving state preemption? Interest groups. The National Rifle Association has successfully gotten most states to preempt municipal regulation of firearm ownerships. Industries. Oil and gas producers in Oklahoma got the legislature to severely restrict municipal regulation of drilling and production activities. Telecom, more recently, has convinced states and the federal agencies to curtail municipal regulation of public rights-of-way and even public property to support the build-out of small cell and broadband networks. There are also ideological reasons. There are legislators who identify the state and the federal government as the only true sovereigns. Other legislators perceive certain local actions such as human rights ordinances, housing, and mask mandates as overreach, and their response to this is to preempt the cities. What is preemption? Preemption is a legislative action by a superior sovereign, in this case the federal or state government, that expressly or impliedly precludes or displaces regulation of a particular subject or activity by a subordinate entity, such as a state, county, or municipal government, that is properly within the jurisdiction of that sovereign. There are a number of forms of preemption. The main two are express preemption and implied preemption. Express preemption is the statutory provision and/or legislative findings that explicitly declare state law or local law shall be preempted. Whenever the statute explicitly provides for exclusivity, subordinate governments cannot interfere by prescribing additional or auxiliary regulations, regardless of whether such regulations complement or further the statutory objective. The statutory provision claiming preemption often includes additional language describing how the subject matter falls exclusively within the realm of federal or state authority. For example, 52 OS subsection 137.1 expressly finds that regulation of oil and gas is a matter of statewide concern and delegates very limited authority to cities. The other type of preemption is what we call implied preemption. Implied preemption is the statute that comprehensively regulates subject matter but is silent or ambiguous regarding legislative intent to preempt. There are two basic subcategories of implied preemption. The first is field preemption. Field preemption is the most common and occurs whenever a statute so pervasively regulates that it effectively creates an inference that there is no room for supplementation by any other jurisdiction. Hence the often used term that a statute occupies the field. Federal immigration laws and consumer safety and drug manufacturing regulations are examples of field preemption. Locally, the marijuana statutes probably constitute field preemption as well, since there's very little room for municipal regulation. Conflict preemption exists whenever a statute does not provide for preemption and does not pervasively regulate subject matter, but a state or local law stands as an obstacle to the accomplishment of a legislatively mandated objective. Conflict preemption may also be found wherever it is physically impossible to comply with statutes or regulation or ordinances from different jurisdictions that govern the same subject matter. Also, any municipal masking ordinance that included schools would thwart the express legislative objective of Senate Bill 658 and it would be impossible for the schools to simultaneously comply with Senate Bill 658 and a municipal mask ordinance. Another type of preemption that is becoming more prevalent is what's known as punitive preemption. And this is a statutory provision that actually imposes civil or criminal penalties to punish members of a governing body for legislating subject matter that a superior sovereign has deemed to be off limits to the other sovereign because it is elected to exercise exclusive jurisdiction. A good example of punitive preemption exists in the gun statutes that have been passed by the state of Oklahoma legislature over the past several years. Essentially, the municipalities have been stripped of any ability to enact gun legislation at a local level. Under the current statute, if a municipality engages in conduct that, quote, infringes upon someone's Second Amendment rights, that individual has the right to bring action for injunctive or damage relief against the municipality and the governing body and any public officials who enforce those statutes, effectively stripping away the protections that are provided by the Oklahoma Governmental Tort Claims Act. Other states, such as Florida, have provisions that actually provide criminal sanctions for passing municipal ordinances that regulate gun rights. There are a number of theories that support preemption. Federal preemption emanates from Article 6, subsection 2 of the United States Constitution, what we all know of as the Supremacy Clause, which provides that Congress may enact laws that preclude state or local regulation on the same subject as long as it is acting within the scope of its authority under Article 1, subsection 8 and subsection 9. The origin of this interpretation by the United States Supreme Court can be traced to the early decisions defining the scope of federal power, including McCulloch v. Maryland and Gibbons v. Ogden. However, the doctrine as it is applied today is largely a byproduct of the proliferation of federal regulation beginning in the 1970s. It's also important to note that Congress can also delegate to a federal agency the power to preempt state requirements when it adopts enabling legislation in a particular field. This is called the Chevron Doctrine, and it comes from a case called Chevron Oil USA versus the Natural Resources Defense Council. A recent example of federal regulations superseding state statutes and local ordinances are found in the FCC's recent efforts to protect small cell and broadband operators from local right-of-way ordinances and pole attachment agreements. The federal courts in the Ninth Circuit have just recently, in a case involving the city of Seattle, held that the Chevron Doctrine is alive and well. State preemption, in contrast, is premised upon court interpretations of state constitutional provisions, which for the most part hold that local governments possess only those powers delegated by the state legislature. Or, as more eloquently stated by Professor Maurice Merrill in his 1952 article on Home Rule, the great weight of American authority proclaims that municipalities have an inherent right of self-government which is beyond the legislative control of the state, and that the state may withhold, grant, or withdraw powers or privileges as it sees fit. I would mention one caveat, however. There is a distinction between statutory cities and towns and charter cities in this regard. That discussion is beyond the scope of this presentation. Preemption analysis. The analysis at federal and state levels is a little bit different. In the case of federal preemption, the first thing you look for is an enumerated or an implied power. Article 1, subsection 8, Article 1, subsection 9. And then also you look at the Supremacy Clause to make sure that it's applicable in this instance. If you find those two things exist, then the next question is there an express congressional finding that or declaration that federal jurisdiction is exclusive? Or does the statute so pervasively regulate subject matter that it can be implied that Congress intended for exclusive federal jurisdiction? Or does this regulation by another sovereign defeat or obstruct legitimate federal objectives? The preemption analysis at the state level is different, and you focus on the term municipal concern. Oklahoma courts have avoided adoption of a bright line rule as to what matters are purely municipal, opting instead to subject such questions to a wider public interest analysis. When this analysis is used, the court strikes a balance between the need for local control and statewide uniformity. Several appellant opinions quote a passage from Dr. Merrill's 1952 work on home rule, and it goes as follows. It's not any single thing upon which we are to concentrate our attention. Rather, we are able to take into account all of the factors which center around the particular exercise of power and strike a balance to determine whether we can say there is a public interest wider than a purely municipal interest. This we cannot do by rule of thumb, but by balancing the interests affected by the matter under consideration. It is this overall consideration of factors involved which offers the best way to a satisfactory explanation of the otherwise oft perplexing course of decision. To sum all of this up, the courts have found that a statewide interest, in other words, the need for uniformity, exists in the following contexts: traffic laws, criminal laws, collective bargaining, military leave, Open Meetings and Open Records Act, annexation, liquor laws, and tax collection. The courts have found that a municipal concern is stronger in the following instances: competitive bidding, if the process is mandated by a charter, such as the case with the City of Tulsa, non-union employees, street assessment districts, initiative and referendum, if it's provided by charter, recall, if provided by charter, and zoning matters. Then there are some areas that the courts haven't really ruled on, but the state has basically staked out a claim, and that is firearms, as we've discussed earlier, oil and gas regulation, telecom and small cell, building codes, and elections. Elections fall into this category because you use the state's machinery, i.e. the county election board, to conduct the elections, and so they have control over the timing and the processes that are followed. I do want to mention some resources that if you're interested in this topic. One is the Local Solutions Support Center, and it's operated by the Columbia University in New York, particularly Professor Nestor Davidson. It's an excellent resource for preemption information. Again, my name is John Dorman, and I would remind you that OAMA has established this program to provide municipal law information, which is accessible through the OAMA website, www.okmunicipal.attorneys.org. Listed there on that website are the names and contact information of OAMA board members and partner organizations such as the Oklahoma Municipal League, OML, and the Oklahoma Municipal Assurance Group, OMAG. If you are a municipal law practitioner, please take advantage of these resources, and you are certainly invited to consider an OAMA membership.